In other news tonight, Attorney General and Minister of Legal Affairs, Senator the Honorable Carl Bethel, commenting on that statement issued last evening by the Office of the Director of Public Prosecutions, clarifying that the magistrate who discharged certain co-accused persons from certain money laundering charges yesterday, in his view, made serious and grave errors in law. Magistrate Ambrose Armbruster indicated to the defendants yesterday that the charges were presented in the magistrate's courts more than 6 months after they allegedly occurred, and that the court has no jurisdiction to preside over a trial involving them, as the 6-month limitation under the Criminal Procedure Code applies. Magistrate Armbruster called it an abuse of process, and he then dropped the 22 money laundering charges against the 3 defendants. The Office of the Director of Public Prosecution statement noted that the law provides that an indictable offense has no statutory time limitation as set forth in Section 213, subsection 2 of the Criminal Procedure Code Act. The statement indicated that money laundering is an indictable offense because it's triable on information before the Supreme Court. The statement also pointed out that the time limit of 6 months to lay charges before a magistrate's court is only applicable to a strictly summary offense. Here's how the Attorney General responded.
If a case could be brought in the Supreme Court, there's no time limit on that. Between 2011 and 2015, the law was changed to allow prosecutors to decide that a Supreme Court case can be brought in the magistrate's court. And the change in the law makes it clear that if a case could have been brought in the Supreme Court, but was brought in the magistrate's court, the 6-month limitation period in the magistrate's court does not apply. The 6-month limitation period only applies to the most minor criminal charges that could be brought and only be brought in the magistrate's court. So the DPP is firmly of the view that the magistrate in the matter made a error of law. And he said he's going to go and try and have this heard as quickly as possible in the Court of Appeal.
Now, the AG also clarified that the charges were brought under the Repealed Proceeds of Crime Act and not the act currently enforced.
The Director of Public Prosecutions was able to produce and rely on the authority of the Interpretation and General Clauses Act of the Bahamas, Section 20, which clearly says that an investigation essentially started under the old act can lead, in effect, to the commencement of charges, even though that act has been repealed. And so the 2 points raised by the magistrate, according to the DPP, as best as I understand it, and is that they are unfounded. They're unfounded, and so he's indicated that he will vigorously seek to go to the Court of Appeal to have both of these findings by the magistrate overturned.